While declaring the right to privacy a fundamental right, Justice Chandrachud of the Supreme Court noted that ours is an age of information. Information is knowledge. The old adage that knowledge is power has stark implications for the position of the individual where data is ubiquitous and all-encompassing presence. It is with the aim of providing a framework to protect this data and addressing concerns over Aadhaar leaks, state surveillance, and what companies like Facebook do with your data, that the Justice Sri Krishna Committee has submitted its report recommending a draft law based on which data will be regulated in India. This draft bill could form the core of the bill the government will place before Parliament likely by September. A little ahead, we'll tell you why this draft law recommended by the panel is a blow to your right to privacy. Are we moving towards a surveillance state? That's ahead. It's Monday, July 30th. Meanwhile, talking about data, Assam will today publish the final draft of its National Register of Citizens. The NRC is the register containing names of Indian citizens being updated for the first time since 1951. The aim is to identify genuine citizens living in Assam and, by extension, identifying illegal immigrants. According to the terms of inclusion, those who cannot prove that they or their ancestors entered the country before midnight on March 24, 1971, that is the eve of the start of the Bangladesh War, will be deemed an illegal immigrant. The cutoff has been determined as per the Assam Accord signed in 1985. The advocates of the Assam movement had alleged large-scale incursion of illegal Bangladeshi migrants in the electoral rolls. Their agitation to disenfranchise and deport these migrants had taken a violent turn between 1979 and 1985. So, what happens to those who don't find mention in the NRC? Reports suggest the number could run into lakhs. It is unclear what will happen to those identified as illegal immigrants. Their deportation to Bangladesh will be easier said than done. Meanwhile, neighbouring states like Nagaland are fearing an influx of illegal immigrants after the NRC is published and have deployed additional forces along the border with Assam. Horrifying details of sexual abuse, torture and exploitation continue to emerge from the Bihar shelter home where more than 24 girls were raped, drugged and beaten by the management and men who came as visitors. The Indian Express now reports that a full 1 month after the Tata Institute of Social Sciences report red flagging sexual exploitation of girls in the shelter was submitted, the state government sanctioned another project to the same NGO that ran the shelter. Brijesh Thakur, who runs the Muzaffarpur-based NGO, has been named in the FIR. The Indian Express quoting official records said Thakur was getting about 1 crore per year from both the centre and the state government to run 5 shelters for girls and women in Muzaffarpur. The big story in tech has been the Facebook stock plunging 19%, wiping out $119 million in market value. Twitter too dropped more than 20%. What explains this? Last week, Facebook announced a drop in users in Europe for the very first time, and growth was flat in the United States, two of the social networking giants' biggest advertising markets. Analysts attribute this to Facebook reportedly forcing users to opt in to give consent to use their data for personal advertising. Remember, one of the stipulations of the General Data Protection Rules, Europe's new privacy framework, states that consent to data collection must be given freely and cannot be a prerequisite for using a service. Other analysts saw the tanking of the shares as a fallout of investor nervousness about events like Cambridge Analytica and what subsequent changes to the social media platform could do to their bottom lines. Vox, in an analysis piece titled "The $120 billion Reason We Can't Expect Facebook to Police Itself," says in a world of shareholder primacy, where corporate boards prioritize maximizing profits and returns to shareholders above all else, it's not reasonable to expect Facebook and Twitter to make moves that might affect their businesses negatively. Advertising dollars, even if they are for divisive political ads from suspicious sources, are still dollars. Engagement, even if it's driven by bought armies, is still engagement. And big money can speak pretty loud. In its first response to election results in Pakistan, India on Saturday said, "We welcome that the people of Pakistan have reposed their faith in democracy through general elections. We hope the new government of Pakistan will work constructively to build a safe, stable, secure and developed South Asia free of terror and violence." The statement did not specifically respond to Imran Khan's offer to hold talks with India. Imran Khan's Pakistan Tehreek-e-Insaf has emerged as the single largest party, but is short of majority. Khan has begun talks with smaller parties and independents to form a coalition government. This election has been marred with allegations of interference by the powerful Pakistan military, which detractors claim fixed the election in favor of Imran Khan, and will therefore continue to have primacy in foreign and strategic policy. As promised, we look at why the draft data protection law is a blow to the right to privacy. The draft law facilitates sweeping state surveillance by providing broad exceptions to consent clauses when the data is processed by the government. What is processing? Processing includes collecting, recording, adapting, indexing, or even disclosing of personal data. Let's look at consent. The bill exempts consent for certain types of data processing by the state. The provision says personal data may be processed if such processing is necessary for any function of parliament or any state legislature, or for the exercise of any function of the state authorized by law, for the provision of any service or benefit to the data principal, or for the issuance of any certification, license or permit for any action or activity of the data principal by the state. Now, this section is extremely vague and open to interpretation. The term necessary for the exercise of any function of the state is as broad an exception as could be given. Now, this section removes the necessity for consent for any service or benefit to the data principal, which is the individual whose data is being processed. This is essentially the very basis of Aadhaar, which the government has been trying to make compulsory for accessing services and benefits, including subsidiaries. The same exceptions are given to sensitive personal data as well. In other words, for the above-mentioned data processing by the state, your consent will not be required to collect, record, or even disclose data, such as passwords, financial data, health data, official identifier, sex life, sexual orientation, religious or political belief or affiliation, or any other category of data specified by the authority under Section 22. The draft bill expressly provides certain exemptions for the security of the nation. Though here the bill makes it clear that collection for such intelligence purposes should be authorized by a separate law enacted through Parliament. Additionally, the draft bill allows non-consensual data processing for what it defines as any public interest. The draft bill also provides for data processing for purposes of prevention, detection, investigation and prosecution of any offence, and exempts consent if authorized by a law. Lawyer Chinmay Arun took to Twitter to point to the problems in the consent clauses. Among other concerns, she points to the provision allowing processing of personal data in the interest of prevention, detection, investigation and prosecution of any offence if authorized by any law made by Parliament. To say, remember, sedition is a criminal offence. Tuhina Joshi, associate at the TRA law firm, says, the grounds for data processing as they appear in the draft law seem to be at odds with the corresponding recommendations of the committee in its report. For example, the committee's report calls for welfare functions of the state to be recognized as separate, non-consensual grounds for processing. It clearly states that processing on this ground is only available for certain entities and certain functions. However, the corresponding provision, Section 13 in the draft law, does not articulate the specific intent to allow processing for only welfare activities and creates a much wider ground for processing. Well, perhaps it's time to change the mantra for firms and governments in this information age from consumer is king to consent is king. Mull on that. We'll be back tomorrow.